Now, there was near chaos at the Kumasi High Court when lawyers for Kwame Nkrumah University of Science and Technology refused to be served a stay of execution filed by Clement Ohene-Asare at the court premises. Ohene-Asare, who claims to be an alumnus of KNUST, filed an injunction to thwart the reappointment of the Vice-Chancellor, Professor Rita Akosua-Dixon, but the court dismissed his request. Shortly after the verdict, the applicant appealed the High Court's decision, but lawyers for the university opposed being served within the precincts of the court. Emmanuel Braikweku was in court and filed this report.
During proceedings at the Kumasi High Court, counsel for the applicants argued the reappointment of the Vice-Chancellor was procedurally wrong per the statutes of the university in extending the tenure of office. He cited a breach of the procedure for the appointment, wherein a 7-member search committee is constituted to propose an ideal candidate for consideration and the advertisement of the vacancy of the Vice-Chancellor position for the application of other viable candidates. But this was opposed by counsel for the defendants, the university and Vice-Chancellor, insisting they complied with the reappointment statutes. Presiding Judge Justice Frederick Tete dismissed the application, describing it as one that lacked merit and capacity. He further questioned the status of the applicants, who had indicated in his application to be an alumnus of the university. Mr. Ohene-Asare failed to convince the court of being an alumnus of the university.
Now in court, there was nowhere in the processes that defense counsel said that they have not breached the statutes and the acts of the university. However, they decided to waste time on capacity and locus. The court said that I am not a registered member of the alumni. When an issue borders on illegality, whoever is bringing the matter to court is immaterial. We are filing a stay of execution just today, and I believe that we will have to wait till a better judgment.
Shortly after the court dismissed the injunction, the plaintiff filed an appeal, and this created a near confusion at the court premises. When the bailiff attempted to serve the lawyers of the university, the lawyers had argued that they needed to be officially served at the university and not the court premises.
He was in court and announced himself as representing the school.
But he said the school. Go to the school and go and serve them. You know service. Who do you serve? Who do you serve?
You guys, if he doesn't want to take it, drop it to him and leave.
Go to the school and go and serve them, man.
University Relations Officer Dr. Daniel Norris Bequin welcomed the court's decision and urged the aggrieved parties to resolve the issue amicably and not resort to the courts.
It's a big relief for us that this matter has been put to rest, so we can proceed and work. Actually, ask that if anyone, as the judge has actually directed, that if anyone has any issue, we should be able to sit down and talk about it peacefully. This is not a matter that we should be bringing to the court to drag the name of the university in the mud.
The court awarded a cost of 9,000 cedis against the applicants. Meanwhile, a staff of the university has also filed an interlocutory application on a similar account against the reappointment of the Vice-Chancellor of KNUST, and this is yet to be heard. From here at the High Court in Kumasi, my name is Emmanuel Braikweku.